I'm Melvin L. Raymond, attorney and counselor at law. Welcome to Raymond Law Live. I want to give a shout out to Better Family Life and the Sims and Bailey Law Firm. Better Family Life is holding their Kwanzaa Expo on December 16th and December 17th. For more information, you can go to their website at www.betterfamilylife.org, or you can call them at, their phone number is area code 314-367-3440, extension 715. Sims and Bailey is a law firm in the Central West End offering quality legal representation and quality legal services. For more information, you can contact them at area code 314-534-0800. Before we get started with our topic today, I want to encourage everyone to remember the individuals and families who lost everything in the California wildfires by remembering them in your prayers, your thoughts, and by donating if you feel the need to. It is devastating to lose all of your possessions in your home at any time, but particularly during the holiday season, it's even worse. So think about those folks in California and count your blessings in this Thanksgiving season. Our topic today is wills and trusts. Wills and trusts. Those two things are estate planning devices. You probably know something about wills, and we're going to deal with that topic first. A will, of course, is a way to distribute your estate at death. So a will takes place at death, of course. The person who makes a will is called a testator, Testator, if it's a he, and if it's a she, it's called testatrix. That is the person who makes a will. Now, what are the requirements for a valid will in Missouri? And this applies in mostly other jurisdictions and other states as well. One is that it is a written instrument, and it must be signed by the testator or testatrix, and it must be, or if the testator, the person making the will, doesn't sign it, then it can be signed by some other person at the direction of the testator or testatrix in the presence of the person making the will. The other thing you need to have a valid will in Missouri and most other jurisdictions is the will must be attested by two or more persons who must subscribe the will in the presence of the testator or the testatrix. So the subscribing witnesses have to do it in the presence of the person making the will. Now you need at least two persons to subscribe to a will, and you subscribe to a will by simply signing the document. And the third thing is that, as far as wills in Missouri, Missouri recognizes wills from other jurisdictions so long as those wills are made in accordance with the statute and of the state where the will has been made. So if you are not in Missouri, you make a will, you move from, let's say, California to Missouri, and you have a will already, you don't need to make another will in the state of Missouri. Missouri will recognize a will that's valid under the laws of another jurisdiction. In that instance of the example, it would be the state of California. And also I want to mention one other will that Missouri recognizes, and that's called a non-cupative will. That is a oral will, and the maximum amount that's allowed for non-cupative or oral wills, and they're only allowed in very limited circumstances, but those are recognized under the Missouri law. and it's a very limited situation. I have not, in my years of practice, encountered a non-cupidative or oral will, but that is one that Missouri does recognize. In addition to the things I just mentioned, the will must be published, and publication, that doesn't mean publication in the newspaper. It means that the testator, or the one making the will, is the one that publishes it. And the way that you publish a will is simply by announcing to, in the presence of subscribing witnesses, that you have a will. You're declaring you have a will, and you have to ask the subscribing witnesses to attest to the will by being witnesses and subscribing to the will as witnesses. So that's what publication means. So you need publication as well. The testator, or the person making the will, has to ask the subscribing witnesses to subscribe to the will. Now, if the normally 2 witnesses are required, however, I recommend that you have 3 subscribing witnesses if possible, in the event that one of the witnesses is either cannot be located or is incompetent or otherwise not legally available. So 3 is recommended, but you must have 2 for the will to be valid. Also, a person that takes under a will is called a devotee or a legatee. Now, that's an interested person in the will. So that's another reason you would need 3 witnesses instead of 2. At least it would be desirable to have 3 witnesses instead of 2, because a person who takes anything under a will is called a devotee. If that person is a witness, then the will may not be, it's valid, but that person's share, the one that's taking on the will, who is also a witness, their share is going to be limited to the amount that they would get if there was no will. So if you're taking under a will, you're a legatee or distributee, then you should not be a witness to a will. Also, the person making the will, the testator or the testatrix, must be a person of sound mind and 18 years or older. Sound mind, of course, it's a legal term, but basically means that the person understands the nature of what they're doing. They know the general nature of what a will is, and they know what they're doing. So that's sound mind. That's nothing too complicated, but that is an element, because if a person who makes a will doesn't understand what a will is and know what they're doing, then the will may be vulnerable to being contested, and it could be thrown out, and with the result that the person it'll be as if they had no will, and the estate would be distributed according to the laws of descent to surviving spouse and children. So it's important that the person be of sound mind. The next thing you need to know about wills is that a surviving spouse, a surviving husband or wife who survived the deceased, can, if they're not satisfied with what's provided in the will, they can take against the will under the Missouri law. And that is true for probably most other jurisdictions. So they can elect to take against the will. So you cannot disinherit a spouse. You can, however, disinherit children. So if you want to not leave anything to your children, then you can do that. But a surviving spouse, has the right to take against the will and take their distributive share as a spouse. Now, what is the surviving spouse's share should they choose to take against the will because they're not satisfied with what you left? That would be if there are surviving children who are the children of both the deceased and the surviving spouse, then the surviving spouse taking against the will gets the first $20,000 of the estate, that's the homestead exemption, and 50% of the entire estate that's included in the will, 50%. The other 50% of the estate of the deceased person is divided among the children, so long as those children are the children of the deceased and the surviving spouse. If the children, and this happens frequently, the children are not they are the children of the deceased, but not the children of the surviving spouse, then the surviving spouse taking against the will gets still 50% of the estate, but she doesn't get he or she doesn't get the homestead exemption. Now, another thing you should know about wills is that if you get divorced after making the will, then all provisions in favor of the spouse are revoked, with the effect that the spouse is pretty much considered deceased as of the date of the divorce. So, if you make a will and get divorced, then the divorce has the legal effect of revoking the will. And that's, I'm sure everybody can understand that. If you are no longer married to someone, then a will that you've made would not be effective as to whatever you left to the surviving spouse. After a will is made, it should not be altered, the document itself. You shouldn't write on it and change it on the document itself, on the face of the document, because that could cause some issues about whether or not the person making the will, the testator, intended to change the will. There is a way to change a will, and you have to do a separate document to change a will. And a will is easily changed by what we call a codicil. So if you want to change a will and you don't want to redo the entire will, and there are in some instances where a person just wants to change a portion of the will. Let's say, for instance, you change your mind about a bequest to or devise to someone, and you want to delete them from the will, then you can do that without rewriting the entire document. You can do a codicil, and if you do a codicil, that's a separate document, and it does have to be executed and made with all the formalities of the will. That is, you got to have attesting witnesses, it's got to be signed, and so forth. All of the formalities as if you were doing the original will. But you just don't have to redo the whole thing if only one part of it needs to be changed and not the entire thing. Wills, of course, can be revoked in other ways. A will can be revoked by the maker of the will or the testator at any time. And there are basically two ways of doing that. One is by a manual or physical act by the maker of the will. You can simply tear the document up, or you can burn it or whatever, or obliterate it, but you have to have intent to do that. So manual act to cancel or obliterate the will with the intent to revoke it. Now, if you have the will and you tear up the wrong document and you didn't intend to revoke the will, then that's not a legal revocation. Of course, if you tear up the will, tear up the wrong document, then there's going to be a problem with finding the will when the time comes. But that's one way of doing it, just simply by the physical act of destroying the will. And the other way to revoke wills is by operation of law, as in the instance of a divorce, then that would effectively revoke the will as to the spouse, the surviving spouse. She would become an ex-spouse. So those are instances. Also, wills can be revoked by operation of law if there's a different alienation of the property that's the subject of the will. That means that if someone has some property, let's say a house, and they include that when they make the will, and then they decide to sell the house during their lifetime, then that will is revoked as to whichever asset that is alienated or transferred to someone else during the lifetime. So assets that's part of the estate, if they're dealt with and transferred before the maker of the will is deceased, then of course the will wouldn't apply to that property. And speaking of property that you can include in your probate estate or included in a will, you can include anything that you want or not include anything that you want. You can make a will, for instance, and only include certain things in there because you've already dealt with other properties which may not become a part of your probate estate. And as far as parts of a will, you should know that the maker of the will should name a personal representative. The term for the person that administers the will used to be called an executor if male or an executrix if female. But the term now used is personal representative, not executor or executrix. Many people still refer to that person who administers the will as an executor, but it's personal representative. So you should name someone as a personal representative in the will, and it would be that person's responsibility when the time comes to start the probate process. And let's talk about what happens at death as far as the will. The will has to be probated, so it has to be found. Now, a will, as with everything else, is no good if you can't find the document when the time comes. So you need the original document to be probated. Copies can be, but that's could be problematic. So you need the original document. You need to, when you make the will, you need to make sure that you put it in a place where it can be located. And that would be, for instance, where you keep all your important papers, or you can put it, some people put it in a safe deposit box, but the personal representative needs, or whoever else you may choose, needs to know where the document is. The location of the document is very important. It's no good if you can't find it, and we need the original. So at death, you find the will, and then the probate administration starts, and that is when the personal representative takes the will, and you have to start the probate process. Wills are one of those things that you do need legal assistance with. That's just one of the things that it's just too difficult without the assistance of an attorney. Typically, the personal representative, when the time comes, simply retains an attorney, and the attorney helps with the process. They get the original document, and they file a document with a petition with the probate division in the county where the person lives to commence the probate process, and then it kind of goes from there. Looking at my time here. So if you want to join the discussion with any questions or comments, then please feel free to send your questions and comments to us on my Facebook account. That's facebook.com/Raymond Law Live, or on my website, that's RaymondLawLive.com, or on Twitter, that's Twitter @RaymondLawLive. So I invite you to send me your questions and comments. So that are the main parts about wills and the probate process once the person goes on to glory. There are two kinds of, as far as administration, we have the two processes really. One is for what we call small estates, and those are estates valued under $40,000 or under, small estates. That's a more quicker procedure. You can do that normally. It doesn't take as long as a regular estate that's valued over $40,000. That requires a longer period to administer, But smaller estates, you file a document with the probate division of the county where the maker lives, and that is processed. You list, of course, all of the assets in the estate, and the court, you submit that to the court, and the court processes that, and usually it could be completed once it's filed within 30 days or so, maybe 5 weeks. I know in some jurisdictions, St. Louis County, it could take as short a period of time as 30 days, 4 weeks, or 5 weeks. In the city of St. Louis, Missouri, it could even take a little less time. So I'm going to see if we have any questions or comments that I'm going to deal with. So that's completes the presentation on wills. Now, I didn't get to the trusts, and that is another device for estate planning, and I may have to break these topics up into two and do the trust segment in the next broadcast next week. So I'm going to take questions now on the wills presentation and do that. I have a question here. What is a living will? A living will really refers to, and it's sort of a misnomer, it refers to a power of attorney for health care. It's got there's some confusion about living wills versus wills, but a living will is just another name for a health care power of attorney. I discussed health care power of attorneys in the first session last week, and of course a health care power of attorney is one where it deals with health care matters only, and it's a document whereby the person that executes the power of attorney appoints another to make health care decisions for you or whoever makes the durable power of attorney for health care. And that usually arises when the person, of course, is unable by reason of being unconscious, in a coma, or whatever, to make their own health care decisions. So a living will really refers to a power of attorney for health care, living will. I have another question here. Who gets to have it if you die without a will? If you die without a will, then that's called you die intestate. That means that your estate, and we're assuming that you have property titled in your name only. That's very important because some property jointly titled would not go to your heirs. It will go to the surviving joint owner of the property. That can happen with real estate, or let's say you have a bank account or some other kind of investment account, and there's a joint owner on there. Then upon the death of you, one of the owners, then the ownership goes to the surviving joint owner. So for property, though, that is held titled in one person's name, that even if you do not have a will, you don't avoid probate. Your estate, if you want that property to go or be distributed to your heirs, then you have to still go through probate. If you own a house or whatever you own and it's just in your name, you don't avoid probate by not making a will. If you die without a will, then the only way to distribute that property to anyone is through the probate process. So many people have a misconception that if I die without a will, then there's no probate. That is not true. Of course, if there's no probate, then the property remains in the name of the deceased person. It's not distributed to their heirs. And the heirs would be, of course, under the laws of descent of the state of Missouri and other jurisdictions, the heirs would be, in the first instance, the descendants, the lineal descendants. Those are the ones who are coming after the maker of the deceased person. That would be first a surviving spouse of the deceased, and then children of the deceased. Those are the lineal descendants. And if there are no surviving spouse or any lineal descendants, then the property would be inherited by collateral heirs, who would include, as far as the priority, the parents of the deceased, and if they're not parents are alive, surviving, then the sibling of the deceased and so forth. Those are considered collateral heirs. We're our time is winding down, so keep the questions coming. I have a question here. Is there a best time to do a will? Um, a little planning goes a long way. You never know what's going to happen even tomorrow or even tonight. So estate planning, and a will is one tool for estate planning, is something to think about. There are other ways of handling distribution of your estate other than wills, but if you think that you want to do a will, then you don't have to be 99 to think that you may need a will or need some form of estate planning. I would recommend that you think about that and maybe speak with an attorney about estate planning. Now, if you have any further questions or comments, or you need legal representation, contact me at my Facebook page, which is facebook.com/Raymond Law Live. That's my Facebook page, or my website, www.RaymondLawLive, or Twitter at Raymond Law Live. I've enjoyed this session, and I want to give a shout out again to Better Family Life for having their Kwanzaa Expo on December 16th and 17th. You can contact them at 314, I gave the number before, 367-3440, or www.betterfamilylife.org. And Sims and Bailey Law Firm, providing quality legal services and expert representation. See you on Tuesday of next week. That's February 27th. And remember, when you fight, know your rights.